Welcome to one of the most emotionally charged courtroom cases we've ever covered. Today, you're about to witness a mother accused of assaulting her own daughter, a 15-year-old. But what seems like a straightforward case of domestic violence quickly unravels into a storm of shocking revelations, disturbing family history, and a battle over parental authority. The judge doesn't hold back, the mother pleads her case, and just when you think you've seen it all, a defense twist challenges everything. Is this mother an abuser, or a parent pushed past her limits by a troubled teen? Stick around. You're not going to believe how this ends.
Samantha Walker. Ms. Walker, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 4th, 2024, an officer was dispatched to a family disturbance call at a residence in Harris County, Texas. The complainant, a 15-year-old, stated that the defendant, her mother, assaulted her after they got into a verbal argument. The complainant stated the defendant displayed verbally aggressive behavior towards her, grabbed a hold of the complainant's left wrist, and said, "If you come near me, I'll beat your ass," and began to engage in a physical altercation with the complainant. The complainant stated the defendant, using both open hands, placed the complainant in a headlock and the complainant felt pain. Both law enforcement and CPS records indicate a history of physical altercations and verbal altercations between the complainant and the defendant, and the officer observed video footage showing the defendant acting as the primary aggressor towards the complainant and observed a minor injury cut on the complainant's left arm.
All right, here's where things start to heat up. The court hears that there's a documented history of violence, yet surprisingly, no prior charges. That immediately raises a critical question. If this tension has been ongoing, why hasn't it led to formal action before now? Is the system just waking up, or has someone been protecting someone else behind closed doors? And pay attention to the judge's tone. He's not just assessing evidence, he's sending a warning. Now's not the time to speak, ma'am. That's courtroom code for, you're digging yourself into a hole. What do you think? Is the judge being too harsh here or rightfully cautious?
So we have prior violence, any prior charges?
There's no prior charges,
No prior injury to a child, felony charges?
No, Your Honor.
Child means 14 years or younger. Ma'am, I'm going to find that there's probable cause to go forward with your case.
No, Your Honor.
Don't. Now's not the time, ma'am. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Anything you say, they're going to use it against you. Guys, what do we do about contact? You know? Yeah, well, so Michael, I need your help.
Yes, Judge.
You know, this is a 15-year-old child. We have a history of violence allegedly between mom and daughter.
Yes, Judge.
Now we have an assault case against a 15-year-old. And according to what Alex says, there's a history of it. It's unacceptable.
Judge.
Do you have a lawyer, ma'am?
I'll be retaining a lawyer, but there's no history of violence between us.
You're calling for a Walker?
Yes.
Which Walker?
Walker. So, what my plan was, and I already spoke to my people about this, is we were going to check the offense report to see where the child was taken. Were they taken to CPS custody, to state custody? Was there some other guardian? Once we're aware of where the child is, we are going to be asking for a no contact order to be granted based off of the allegations of the history.
What about now? Is there something that we can do now as far as?
Let's unpack what's happening legally here. The judge and prosecution are pushing for a no-contact order based on the child's allegations and prior incidents. This isn't just a temporary band-aid, it's a protective legal wall that would prevent the mother from even being near her daughter. Think about that. No school pickups, no doctor appointments, completely cut off. Yet, the mother insists there's no history of violence. This contradiction is huge. Is she being gaslit by the system? Or is this a classic case of denial from a parent who's crossed the line one too many times?
Finding out where the child is?
Well,
you know?
we're going to call CPS today and see if they're in state custody. The offense report also might indicate where it is. If not, we can call the officer and they should know.
I'd like to, because I think it's serious. And if we have a history of violence, I don't want that to happen anymore. I know that you're telling me no, but I have other people that are telling me differently.
I've never.
Okay, well, ma'am, don't. Now's not the time. But my primary concern is the protection of every single person in Harris County, bar none. That's it. Especially if it's a child. And
I'm not a threat to my child, I promise
you
you.
are now charged with assault, ma'am, on that 15-year-old child.
I never assault.
Stop. Now's not the time. I'm just trying to tell you, if I find that there's a history of violence with the child, I'm going to order you not to have contact with this child.
I understand.
As it stands now,
But
I'm
history
entering
of
in what's called a
violence.
magistrate's order for emergency protection that identifies EJ as a protected individual. You
I
cannot,
have to take her to appointments and stuff like that.
please listen. Okay, I know that you're trying to think of stuff to say,
No,
but
I'm
I
being
want you to
honest.
listen because this is very important stuff. And if you don't hear it correctly, you do something to violate this court order, they're going to file additional charges against you. I'm entering in an order for protection for that 15-year-old child. She's now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Technical Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Typically, this also comes with a residential restriction that you're not to go within 200 feet of where she lives or where she works. You understand? I'm entering this order now. We will try to figure out about how we go from here, but my only concern is the protection of this child. To me, nothing else matters. I know that you're telling me one thing, but the evidence will show what it shows, and that's going to point to whose side is correct. So for now, I'm just going to have them reach out to see where the child is and how we go forward. So for now, I'm going to have you sign a reset, and then we'll just have you take a seat in the jury box, please. Okay?
No, Judge, we did it. So, Judge, I met the defendant with defense in the room.
Oh, okay.
I'll let defense.
Your Honor, I showed him some video of the alleged assault, I believe. Of course, I haven't gone through the state's discovery, but this, in my opinion, is a child out of control. She's on juvenile probation in Tarrant County, according to her mother. The complaint says that she caused bodily injury by grabbing her. The complaining witness has a statue. She's threatening to get a knife. She's bigger and stronger than my client. My client's called the police numerous times.
This is why we appoint.
And so
there's
I
always
think-
two sides, right?
I think this
Always.
is almost enabling the child when the police saw all this, but they're so sick of going out there. They're like, we're somewhere. It's
But I don't understand why they wouldn't. If you see this, Michael, did you see it?
I saw the video, Judge.
Okay.
Based off of what I saw and what defense told me, I'm unopposed to removing the residency restriction, to not granting a MOAP at all, and to just.
No more.
I wouldn't.
Okay, I mean, if that's what you think, I'll go with what you think. I
Based off what
think,
they're telling me, Judge, and I did corroborate some of the information as well. We're just going to subpoena the CPS records to take a look.
come up, Ms. Walker, come up. So I guess,
Now this is where the courtroom dynamic flips. Suddenly, we're hearing from the mother, and her side paints a very different picture. A daughter on juvenile probation, a parent who's tried therapy, medication, CPS intervention, and still chaos. The judge even sympathizes, referencing his own teenage years. This moment is raw and real. It begs the question, when a child is spiraling, how much can a parent really do? And at what point does discipline turn into desperation? Sound off in the comments. Have you ever seen a situation like this in your own family or community?
shh. The $25 million question is, how do you wrangle in a child who's out of control?
I've been doing everything in my power to love her, do everything to help her get some type of mental help. I've had her admitted to several programs. I've even contacted CPS myself personally, had them come out to the house. She got up and walked out on us. I've tried therapy. I've tried medication.
Hell hath no fury as a scorned 15-year-old. I tell you
None.
what, I mean, I
None.
remember I was 15. Oh God. And I hope it doesn't, I mean, I know it's going to happen to me, but what's she on probation for?
Trying to stab her older sister, my other daughter,
And that's in Tarrant County,
in Tarrant County.
and a juvenile case.
As a felony.
Okay. I'm at your disposal. I guess whatever you want, man. I'll take off I won't do the order for protection. Just be careful, you know. I won't put I'm not.
This is a huge decision. Despite all the evidence and the earlier urgency, the judge decides to drop the protective order and remove all conditions. Because he's seeing something deeper, a parent who's exhausted every option. This choice walks a legal tightrope: protect the child or support the parent trying to survive an impossible situation. Judges are trained to uphold the law, but here we're seeing something rare: empathy from the bench. Was this the right call, or could this backfire catastrophically? You tell us.
Michael, I'm not gonna put any conditions either, I guess, you know?
I would just say no for any harassing, Judge, if the court's inclined to do that. Some sort
I
of.
mean, how do you handle a 15-year-old? That's, you
But how
know?
can you be a parent if, it's almost like you're disarmed and the child can do whatever she wants, and if you touch me, well, you're going to jail.
Correct.
No, I mean, imagine that. The child will have unfettered access to.
And the first thing I told her, if you feel triggered, you can leave and take a walk. Well, that walk turned into her being gone for 7 days.
My Lord. You gonna bring her here? She'll come here. I can try to talk to her.
Yeah,
Show her to jail. I don't
she's been
know.
in jail in Tarrant County already because she continues to violate.
That's juvenile detention, is what I'm saying.
I don't know. I mean, I don't know how much. I don't know how worse juvenile detention is versus regular.
And she had an ankle monitor when it was cut off.
It's not like jail.
Really?
Yeah, they're in plain clothes, they're not in handcuffs, they have plenty of hours.
Really?
It's completely different.
Might as well be a playground.
Yeah.
Not like Dr. Phil where he's
No.
to the.
No.
Okay.
No.
I'm not gonna put any. Just be careful. You know, it's evident she's bringing you down too, and I'm so sorry for it. You know, you're welcome to come bring her here. We'll try to help you out.
Yes.
If she'll listen to me, I'll try to talk to her, or whatever you need. We're at your disposal, you know.
Thank you, I appreciate that.
You ever need funds for anything, just let me know.
Okay.
That's why, I wanted to point to someone, because there's always two sides, right? We get one side here, but a lot of times you don't get the other side, and a lot of times we take that for granted, and it's good to have another ear in, just so that we always know, we get a complete picture, and it's just so important. So I'm sorry you're going through that, and I hope it gets better. If you keep loving, I gotta imagine she's gonna get better, really. Because I tell you, I was the same way. Hell on wheels, and if it weren't for my folks, holy moly, I don't know where I would be, really. So, okay, man, thanks. So we've given you a lawyer, just stay in touch with James. He'll tell you when to come back, what you need to do. I'll waive your appearance. You don't have to waste your time coming to court. Just stay in touch, and then you guys work it out, okay? Okay. Best of luck to you.
So the protective order and the.
No conditions,
No conditions. Okay.
Just
hold on.
Yeah, we'll shred it. Just shred it. Okay.
State of Texas versus Catherine Welch. Ma'am, are you Catherine Welch?
Yes, Your Honor.
And Ms. Welch is here with her attorney, Mr. Gertz. State's attorney is present. Ms. Welch was previously in court, entered a plea of guilty to driving while intoxicated third or more, as well as a prior offense, which made it a second-degree felony offense. There was no agreement with regard to punishment. I have received the pre-sentence report, and has everyone had an opportunity to review that report?
We have, Judge.
I have, Your Honor.
Are there any additions or corrections to that report?
Not from the state, other than I want to acknowledge I have received Mr. Gertz's sentencing memorandum. So
I'm going to get to that too in just a second. Any additions or corrections?
Aside from the one comment that I make in the sentencing memoranda about a comment that she made about rehabilitation, I think it's more of a clarification, so I'm happy to touch on that. But other than that, we don't have any additions or corrections.
Okay. And Ms. Malfino has already stated, as well as I have received the sentencing memorandum at 5:47 p.m. yesterday. Going to point that out for the record.
The Harris County judge got her sentencing memoranda at midnight, so.
Well, it was reviewed quite early this morning, but I did review it. Ms. Malfino, you've had time to review it as well?
same, Your Honor.
Okay. Other than that, I think you all should have a couple, there's only a few, but there were some jail incident reports that should have been provided to council. Did you both receive those as well?
Yes, Judge.
I did.
Okay. Is everyone ready to proceed with sentencing then?
Yes, Judge.
Yes.
All right. Mr. Gertz, do you have witnesses?
I'm not going to call any live witnesses unless the court requires it. When we have a person present from the Dream Center, if the court wants to inquire about that, I would essentially let her come up and talk if you want to have that conversation. But
Okay.
I think, our focus here is going to be on the topics that we talk about or write about in the sentencing memo, and, just sort of allowing if the court decides to do what we're asking you to do, we are open and welcome to whatever the court requires of her
Sure.
to enter and successfully complete. We just wanted you to have that option on the table as well. That
Okay.
is an option that doesn't cost the court anything. Or
Right.
the state anything.
And for the record, I'm aware of the Dream Center and their program and what they do. And so if I have any specific questions, if we get to something where I would need that, then I appreciate them being here and I'll ask those questions. Ms. Malfino, does the state have any witnesses?
No.
All right, then argument.
Judge, I want to, I recognize this is a unique case and a unique ask that we're making here. This is not something small that we're asking for. I have sort of personally taken Catherine on over the last 3+ years, I guess almost 4 years, as a project for me, if that makes any sense. And what I mean by that is I really wanted to put to the test, could this person do everything that I asked her to do to at least get her an opportunity?
Now we shift to a second defendant, and it's a completely different kind of courtroom drama. Catherine Welch has a DWI felony, but what follows is one of the most passionate defenses we've ever heard. Her attorney doesn't just argue her case. He vouches for her growth, her mental health journey, and her years-long commitment to sobriety. It's not about a second chance. It's about whether the justice system can recognize true change. When someone does everything they're asked to do, how much should their past still define them? This moment is powerful, and it redefines what accountability can look like in the courtroom.
Opportunity to be here in front of you asking what we're asking for. She exceeded my expectations by doing the 90-day inpatient rehabilitation. And while she was there, she started to explore with her counselors and her therapists there some of the underlying issues that went beyond just physical addiction, but actually had to do with her mental health and some of the things that she's experienced in her life. I'm not going to detail them on the record, but the court is aware of what those things are. Incredibly traumatic events that I think she had repressed and had never really addressed and explored. And so those counselors recommended not just aftercare, but a specific outpatient program to address some of the trauma issues that she's had. She went and checked into that program, stayed for basically a year, and again, did everything we asked her to do. When I told her to go get her own drug patch, I told her to go get her own interlock device. She did all of that. Those records should be attached to the memo. She was successful, has been following the rules, doing everything we've asked her to do, had been going to AA, had gotten a counselor, actually reached out and befriended the director of the Dream Center to try to figure out what she can do next to sort of commit herself to her sobriety and to fixing the mental health issues that I think stem from the challenges that she faced as a young person. Sometimes it's easy to look at one side of the ledger, the rap sheet or the criminal history, and think that defines this person. What I have been fortunate enough to do is to really dig down and get to understand her as a human, and see that all the progress she's made, all the effort she's made, and see what she's done well and all of the problems that she's been addressing well. She's obviously very anxious about this day, but we've been looking forward to this day as well to be able to present that. And I want to go down on the bottom of page 2, address what I was talking about in the CSI. So that I'm not saying that this wasn't the words that came out of her mouth, but when she was asked by one of the examiners in the probation report, she felt she needed treatment. She said she didn't feel like she needed treatment. She wasn't opposed either. I want to clarify what we mean by that. And I say this here, but what she would say, I think, is she did 90 days of detox rehab related treatment, has continued aftercare, has continued mental health care. But in terms of going to a program that is specifically targeted at people who are currently using or currently intoxicated, I think she thought that wasn't the direction that would be ideal. She will do whatever you want her to do, but I wanted to explain what that comment means. And so, because a lot of times, as you know, Judge, private rehabilitation programs will just reject you if you've been clean for 3+ years, as she has. And so they just won't even accept you at all. So I think that was just a misunderstanding or a miscommunication between the probation officer and Catherine. But nonetheless, she's willing to do whatever the court chooses here. Additionally, we've been in contact with her current parole officer. They are willing to keep her on parole instead of revoking her, depending on what the court does here. And so that was encouraging as well. I think we had the same kinds of conversations with them about her recovery and about her efforts. And so I think that was an encouraging sign from
2 cases, 2 women, 2 drastically different stories, but one central question: what does justice really look like? Whether it's a mother trying to survive her daughter's rebellion or a woman fighting to rebuild her life after addiction, this courtroom revealed the gray area between law and humanity. Judges don't just rule, they listen, weigh pain against the law, and decide what society should value. What do you think? Did the judge get it right in both cases? Drop your thoughts in the comments. And if you found this case as shocking and thought-provoking as we did, be sure to hit that like button, share the video, and subscribe for more jaw-dropping courtroom breakdowns every week.